It's no secret that your home is usually your most valuable asset in your separation or divorce. What happens to your matrimonial home in the separation and divorce process? This is a critical question for you. Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham region and the GTA. The information in this video only applies to married spouses. It does not apply to spouses living in a common law relationship. First, you need to understand that your matrimonial home is defined as the home in which two married spouses ordinarily reside prior to their separation or divorce. Both you and your spouse have an equal right to possession of your home unless you and your spouse agree otherwise, or a court makes an order that only one spouse can live there and the other spouse must move out of the home. You can go to court to get an order for what's called exclusive possession of the matrimonial home. This means that the court would order one spouse to move out of your home. However, this is not an easy order to obtain. As well, both you and your spouse must agree to sell your home, regardless whether both you and your spouse are entitled to your home, or only one spouse is entitled to the home. Your home impacts another important part of your family law case. That is the issue of dealing with your property and assets. The family law states that for dealing with property and assets for married spouses in Ontario, this is called equalization of net family property. You must determine your net worth by determining or calculating the value of your assets and the amounts of your debts on the date of marriage and the date of separation. Your former spouse must also make this calculation. Then the spouse with the higher net worth must pay half the difference to the other spouse with the lower net worth to equalize their net worth. However, one important exception to this process is the matrimonial home. If you or your spouse own the matrimonial home on the date of marriage, you cannot deduct the value of this home from your net worth if you own the same matrimonial home on the date of separation. This can make a big difference in calculating the outcome or determining the outcome of the property assets family law issue in your case. The entire value of the matrimonial home must be included in the calculation of the owner spouse's net worth. You can only avoid this problem by having a marriage contract that states that the owner spouse can deduct the value of the matrimonial home that they owned on the date of marriage if it is the same matrimonial home on the date of separation. In the final analysis, you can only do three things with the matrimonial home when you separate. You and your spouse can purchase the other spouse's interest in the matrimonial home. One spouse can transfer their interest in the home to the other spouse to satisfy part of the equalization payment owing, or the whole amount of the equalization payment owing, or the home is sold. You can see how this issue can get very complicated so quickly. Make sure you spend some time discussing this really important issue with your family lawyer. If you have any questions about your separation, divorce, or family law case, and you'd like our help, there's a few ways to contact our office. You can leave a message on my Facebook law office page, that's O'Malley Family Law. Visit my website at www.canadiandivorcelegalaladvice.com or call me directly at 905-434-8837. We would be happy to speak to you. Oh, by the way, did you know you can protect your family law rights and get essential information on settling your family law issues with your former spouse with the daily, indispensable family law advice and tips at my free Facebook group? Go to Facebook and search Durham Region Separation and Divorce Legal Support Group in the top search bar. You'll find the group and join. Thanks for watching this video. Make it a great week. I'll talk to you soon, and take care.